Moving on to video number 2, Malabika ji, my first question is what are the main findings of law and economics?
Some of the important findings are I am going to discuss right now. One of the fundamental problems of tort law is how to apportion harms which ensue interactions between injurers and victims. A rule which apportions the harm between the injurer and the victim is called a liability rule. A variety of liability rules are employed in tort law. Most important of them are strict liability with the defense of contributory negligence, no liability, negligence rule, negligence with the defense of contributory negligence, comparative negligence. Now, economic analysis of these rules has established that the rules of strict liability with the defense of contributory negligence, negligence rule and negligence with the defense of contributory negligence and comparative negligence are efficient. The rules of strict liability and no liability, however, do not always yield efficient outcomes. Now, a general theorem regarding efficiency of liability rules has been established. In fact, Professor Satish Jain has contributed significantly to this. It states that a liability rule is efficient if and only if it satisfies the condition of negligence liability. The condition of negligence liability, which is there explained in his book Economic Analysis of Liability Rules in detail. It is on page 12 also of the introduction to law and economics. I will be going into detail about these books later on. Now, the condition of negligence liability requires that whenever the injurer is non-negligent and the victim is negligent, the entire loss in case of occurrence of accident must be borne by the victim. I repeat, whenever the injurer is non-negligent and the victim is negligent, then the entire loss in case of occurrence of accident must be borne by the victim. And whenever the victim is non-negligent and the injurer is negligent, the entire loss in case of occurrence of accident must be borne by the injurer. Now, this is with respect to tort law. Two important remedies with respect to property rights are injunction and compensatory damages. Economic analysis has shown that if transaction costs are high as to preclude bargaining, then the remedy of compensatory damages is preferable to injunction from the efficiency perspective. On the other hand, if transaction costs are low, then the remedy of injunction is to be preferred over damages. Finally, with respect to contract, economic analysis of remedies for breach of contract has shown that while the remedy of expectation damages is efficient, the remedy of reliance damages is not. So, these are the main results, main findings.
Thanks. Now, this brings a question that does law and economics constitute an explanation for common law?
Now, on the basis of the results which have been outlined in the area of law and economics, it has generally been concluded that by and large common law is efficient. Some scholars in view of this have advanced the thesis that efficiency provides a unifying explanation for law as it exists. I repeat, some scholars in view of this have advanced the thesis that efficiency provides a unifying explanation for law as it exists. There are two important reasons, however, for not accepting efficiency as a unifying explanation for law as it exists. Number one, some of the efficiency results disappear when more realistic assumptions are obtained in place of assumptions employed in standard law and economics literature. Now, how can we say that? For example, it was mentioned earlier that negligence rule is an efficient rule. The results establishing the efficiency of negligence rule, however, is based on the concept of negligence being defined as the failure to take at least the due level of care. I repeat, the results establishing the efficiency of negligence rule, however, is based on the concept of negligence being defined as a failure to take at least the due level of care. Now, this notion of negligence may not be the one that is used. So, from an analysis of actual court cases, it appears to be the case that often courts consider negligence in terms of the existence of or otherwise of cost justified untaken precautions. So, what are these? If negligence is defined as the existence of a cost justified untaken precaution, then it can be shown that negligence rule is not efficient. Now, we will discuss the concept of cost justified untaken precaution. It has been discussed in this book on tort law. So, while I am discussing the references, I will go into a little bit of detail on that. Indeed, with negligence defined as cost justified untaken precaution, there is no liability rule that is efficient. The second point that we were discussing is this, that even if it is assumed that all rules which are used in practice are efficient, but together they constitute only a proper subset of all efficient rules, one still has to explain why some efficient rules are used while others are not.
You made a number of references to efficiency and efficient. My question is, why should efficiency matter at all in the context of law?
Yes, this is a highly contested question. So, efficiency is clearly a desirable property. It is certainly not the case that the efficiency requirement will always conflict with the fundamental values of justice and fairness. Now, if the choice is between two equally just laws, right. So, if the choice is between two equally just laws, but differing with respect to efficiency, it would clearly be desirable to go for the more efficient law.
Okay, thank you. That brings us to the end of video number 2. In the next video, we would go into more specifics about how should economics and law be taught by the aspiring faculty. Thank you.